I'm John Hanson, the managing attorney of the American Law Firm. And what you're about to view is a short video on frequently asked questions about trusts. And if you or anyone you know has questions regarding this issue or any other legal matter, call the American Law Firm today at 815-394-1776 for a free consultation. Our attorneys have decades of experience that can help you navigate through the options available to you to reach the goals you have in mind. There are many types of trusts, but the two most commonly encountered by individuals are revocable trust and irrevocable trust. Now, this video will deal largely with the most common of those two, revocable trust. A revocable trust often goes by two other names as well, an inter vivos trust or a live-in will. This is a trust set up by a person or couple where certain assets are put into the trust to provide certain benefits. The trust is controlled by the creator of the trust, called the settlor. And this person can end the trust at any time, and they can put property into it and remove property from it as they please. The revocable trust is a legal document drafted by attorneys that essentially provides directions as to who inherits the property in the trust, and it sets out instructions as to how to manage the property in the trust. The documents look like a will and will have beneficiaries listed in it like a will, but it provides a much greater benefit than a will can provide for most people. The trust provides three basic benefits in most cases. One is privacy, the second is simplicity, and a third benefit is probate court avoidance. So first, a trust provides some privacy because certain assets will be owned in the trust's name rather than just in the name of the person themselves. This can help prevent people from being able to snoop around and find out what assets a person owns. Also, in terms of privacy, a trust can avoid the necessity of probate court being an open case. Now, probate cases are in the public record like a lot of civil court cases are, and anyone can view sensitive information in a court file. So a trust helps avoid that as well. As for simplicity, the trust provides a direct passing of assets from the deceased person to their heirs without any court involved. And it acts as a central warehouse of various assets, which is a convenient arrangement for most of your property. The trustee is the person appointed to manage the trust, and it's the person who has control over the trust. Most people appoint themselves as trustee over their own living trust for convenience and control of their own assets. Everyone should have a living will, regardless of their financial situation, because a will addresses certain basic needs like parenting and guardianship issues over minors and other basic stuff you want to set out in every situation. But not everyone needs a trust. A trust is only necessary if a person owns certain property or certain assets. Funding a trust means moving assets into the trust, which is accomplished by renaming property like real estate deeds or bank accounts into the trust name. Now, very often we'll have people come into the law firm who had a parent who had a trust prepared by a law firm, but they never had the trust funded. And a trust without assets in it is basically a useless document. So it's important not to only have a trust prepared, but to move assets into it that need to be moved. Assets left out of a trust would pass through the will if the person had a will prepared. Now, filing and then litigating a probate court case could then be necessary without a trust because the trust provides that direct inheritance to the heirs. But that would depend on the assets the person had at the time they died. Now, having a trust prepared for you is an important event, and it affects so many things after you die that you should spend some time with an attorney before having one prepared. Call our office today at 815-394-1776 for a free consultation to discuss your particular legal issues with our attorneys.